Hello everybody and welcome to Lawyer Stuff. This is Advocate Aishwarya Sinari and today we are going to talk about a case that changed the framework of legal system in India. It is Joseph Shine versus the Union of India 2018. Now the facts of the case are as follows. There was a man in Kerala who committed suicide after he was falsely alleged by a female co-worker for having raped her. Now this female co-worker was a married woman and alleged this person of having illicit sexual relations with her. This allegation was made purely out of vengeance and purely out of malice. He couldn't take that blame of the allegation that was falsely made against him. He couldn't take the burden of being falsely implicated for such a crime, and he was charged under section 497 of IPC, which is adultery, after which he committed suicide. This man's friend, Joseph Shine, who was a hotelier and not an Indian resident, he was an NRI but filed a PIL for his friend. He brought to light this issue of section 497 of adultery. In 2018, he openly challenged the constitutionality of this law in the court by filing this PIL because it was made in the Victorian era, that is around 2 centuries ago, and said that it did not hold any place in the modern society. Now, what is section 497 of IPC? Section 497, which is adultery, states that if any man has sexual intercourse with a woman who is or he knows to be is the wife of another man without the consent of her husband or the connivance of her husband, if that man has sexual intercourse with that woman, that is considered to be as adultery. Now, what is the catch here? There are 3 things. Firstly, a woman cannot be punished. So as per this section, it provides for the man to be punished, but the woman, no charges are framed against her even though she is the abettor in that particular crime. Secondly, if it is done with the consent and the connivance of the husband, then it is not considered to be an adultery. And thirdly, a woman cannot file a case of adultery against her husband. It is not that this section came up for discussion for the first time in the year 2018. This had come up many a times, but also surprisingly it was declined and said that this section was constitutionally valid until the year 2018 in the case of Joseph Shine versus the Union of India, and that is why this case holds a special regard. When this section came for discussion, the Chief Justice of India, Deepak Mishra ji, said that women are not the property of their husband and the husbands are not their masters, because this section violated Article 14 of the Indian Constitution, which talks about equality, and 15, which talks about non-discrimination. Also, adultery as a section under IPC was decriminalized. So adultery was not considered to be coming under the umbrella of crime anymore. It was not considered to be a crime because doing so would clearly mean an extreme intrusion of privacy into the marital sphere. As we all know that sexual autonomy is something that is personal. It comes under Article 21 of the Indian Constitution as our personal liberties. So interfering in something that is so personal, and especially in the sexual autonomy in a marital domain, is considered to be an extreme violation of privacy, and that is why it was decriminalized on the whole. Although adultery is decriminalized, it is considered to be unethical, it is considered to be denigrating and degrading the very institution of marriage, since the institution of marriage itself is built on the foundation of trust. So it is decriminalized legally, but still is a civil wrong and a valid ground for divorce. Thank you for watching. For more such interesting legal updates, please like, subscribe and share the video. Thank you.